We're back again with the next part. I don't know which number we're on anymore. I'm doing it too fast. But thank you guys for liking the videos, and I'm open to comments. I'm not gonna debate with anybody. You know, them cops don't need any more public defenders. You know, we don't need the public defending them no more. They got all the good lawyers. They got all the good lawyers. So I left off on an unconstitutional doctrine, practice, custom, and policy of qualified immunity which contributes to the continued violation of rights, which include but are not limited to the First Amendment rights, Second Amendment rights, Fourth Amendment rights, Fifth Amendment, Sixth Amendment, and so on and so forth. Those who engaged in the corrupt practice were praised and promoted for it rather than disciplined for the misconduct. Respondent superior, Monal doctrine element met. And for sweeping this under the rug, Jerry Miller, state's attorney for Elk Point, Union County, was promoted after violating 16-18A, special responsibilities of a prosecutor. Stephen Jensen, sentencing judge, was promoted to Chief Justice of the South Dakota Supreme Court, and habeas judge Arthur Roosh was promoted to the Senate. None were disciplined for their part in the misconduct, instead receiving promotions after the 2010 habeas cover-up, malicious prosecution, and wrongful conviction, and concealment in conspiracy with the Department of Corrections and the South Dakota National Guard, who transferred and concealed petitioner from Unit C, sending petitioner to bag sand for the flood of 2010, or their so-called disaster declaration by Dennis Doggard. And I didn't get my 90-day sentence cut on that either, fucker. The disaster declaration was because of that habeas corpus in South Dakota during appeal of the state habeas. Philip O. Peterson. It was forced labor. I did not volunteer to go. I was forced to go, or they were gonna put me in solitary confinement for refusing a work order. I was not confined to labor. I was not sentenced to any labor. So I need that compensation for all them sandbags I filled from South Dakota too. Forced labor. Court-appointed defense assistants customarily render ineffective assistance of counsel, intentionally render ineffective assistance of counsel, making false and misleading statements, misrepresenting facts to clients in an effort to obtain involuntary admissions of guilt to crimes they did not commit. The doctrine of qualified immunity has contributed to the death of George Floyd, Breonna Taylor, Jayland Walker, Philando Castile. In other states, Jacob James here in Sioux Falls, South Dakota, and the brutal beating of Mike Hoft of Sioux Falls, and contributed to this bold and violent assault under color of law by the named defendants Justin Ritter and Aaron Bobier upon the petitioner. So I'm appealing all these court cases, and I'm appealing to the public. So when a court orders something and they make a judgment and I appeal it, you can't give that order no respect. You cannot give that order no respect. And the other judges that review a case, they're not supposed to give any respect to that judge's order. They have to review de novo. So when a reviewing court, an appellate court reviews a case and they are quoting word for word or sections of the lower court's order that got appealed, they're giving it respect. They're deferring to the court. They're not supposed to defer to the court order that is being appealed. So they're violating their own rules. And contributed to this bold, so this doctrine of qualified immunity, they know this. So they don't have fear, but they know they have the favor of the courts. So that doctrine of qualified immunity is contributing to these continued acts of violence and aggression and terrorism. They're terrorists. They're human traffickers and smugglers, dude. Under color of law by the named defendants Ritter and Bobier upon petitioner. The doctrine of qualified immunity contributed to widespread practice and emboldened the state's several police officers of using excessive force, affecting unlawful arrests, kidnappings, and justifying murders, as evidenced by the death of several people in violation of the Fourth Amendment. They're being deprived of life without due process. As official acts and acts as performed under color of law. They were harbored from justice and protected from liability for committing criminal acts of kidnappings, murders, extortion in the form of cash bond, assaults and batteries, and continually appointing surrogate prosecutors to pose as defense assistants who, instead of defending or assisting the accused, systematically coerce, advise, and threaten into waiving rights with unnecessary delays, unnecessary psychiatric evaluations, and the constant recusals of and discharge of appointed defense counsels, motions for delays, and motions for attorney discharge from representation in order to obtain involuntary admissions of guilt. They'll keep delaying it until you plead guilty. The only time they give you a speedy trial is when they got the case and they got all the evidence and you actually committed the crime. But if you didn't do the crime, they're going to delay you until you get tired of it and just plead guilty. The municipality and the whole state of South Dakota failed to discipline Jerry Miller for his malicious prosecution, only admonishing him on the record to give the appearance of taking disciplinary action, while off the court's record, he was promoted, as well as his colleague Stephen Jensen. Chief Justice of the South Dakota Supreme Court and habeas judge Arthur Roosh was promoted to senator. Birds of a feather flock together. If Chief Justice Stephen Jensen was doing this stuff and he's the chief of the other 4 justices, they're just as bad as him. Rather than discipline its officers and fine them, when you guys transported me, South Dakota, when you transported me and concealed me from this habeas and made it look like I wasn't in contact with my attorney or whatever, you guys owe me that. That's a civil matter, dude. Rather than discipline its officers, the officers are promoted. The Monell Doctrine was decided in Monell versus Department of Social Services of the City of New York, and gives victims of police. I don't want to call myself a victim. I know there's victims out there, but I survived. I like to think of myself as a survivor. The victims, may they rest in peace, and I hope they receive justice. And after this, victims and survivors of police prosecutorial and judicial misconduct, a way to seek recovery in civil lawsuits. Under the Monell Doctrine, a municipality may be held liable for an officer's actions when the plaintiff establishes the officer violated their constitutional rights. That's established. And that violation resulted from an official municipal policy, an unofficial custom, or because the municipality was deliberately indifferent in a failure to train or supervise the officers. Failure to train or supervise. And I think it goes in there too when it failure to discipline, the punishment. Put in simpler terms, what this means is that cities are responsible for their employees' behavior only when their employee is acting through an official government policy. The plaintiff is suing a municipality for implementing customs or policies that cause the unconstitutional behavior, not suing the municipality for the employee's actions. Well, I'm suing them both, official and personal capacity. Because this petition stems from a criminal complaint in state of South Dakota versus Gomez, alleging criminal assault on law enforcement and habitual criminal Part 2 information, Gomez is entitled to assistance of lawyer to complete this writ petition so as to comply with Sixth Amendment constitutional principles. Petitioner requested counsel on the grounds that he is unlearned in the law, is too poor to retain counsel, and without it, he will be prejudicially treated and barred from bringing this case forward as pro se. And that's what they have demonstrated. They demonstrated that. A pro se litigant proceeding in forma pauperis has no constitutional or statutory right to representation by counsel. However, representation by counsel may be appropriate under certain circumstances after a finding that a plaintiff's claim has arguable merit in fact and law. Mallard versus United States. Let me get some of that on here. And all this stuff, it should be public record. I submitted this file in Gomez versus State of South Dakota, 420 CV 04151. It's one of the last documents I submitted before this last court order that I just got 2-3 days ago. Mallard versus United States, Section 1915D, now Section 1915E1. Does not authorize a federal court to require an unwilling attorney to represent an indigent civil litigant. The operative word in the statute being request. They refuse to even request that a lawyer. Keep watching, like, share, follow for more.